Hello, Nadia. Today we will talk with Nadia Volkova, the lawyer, founder and director of the Ukrainian Legal Advisory Group in Kyiv. This group is a part of an alliance of Ukrainian human rights organization called a 5 p.m. coalition. And of course, this is the obvious reference to the hour when in 2022, in February, Russian invasion started. It was 4 a.m. in Poland, but in Ukraine it was 5 a.m. This coalition is devoted to the documentation of war crimes and crimes against humanity committed during Russian aggression in Ukraine. And we are fully aware that the coalition is called 5 a.m. and it is reference to the events of February 2022. However, we are fully aware that aggression started already in 2014. In 2014, because of the annexation of Crimea. This means that the armed conflict between Russia and Ukraine entered in its 10th year. And from your perspective, you are representative of the civil society, which is devoted to the documentation of war crimes. Do you see any changes in the pattern of commission of crimes related with this aggression?
Yes, I wanted to add that in addition to documentation, we're also focusing a lot of our attention on all the accountability efforts to make sure that the victims of this armed conflict get meaningful justice. I would say yes and no in answering the question, because from 2014 until 2022, the partners of crimes were very similar to what was happening following the full-scale invasion. It's just the scale is bigger. Probably the only difference, I would say, on a larger scale is the missile attacks. We didn't have those until 2022. And this is a very, scary, frightening addition. But in terms of illegal transfer or deportation, internal displacement, illegal detention, torture, extrajudicial killings, they were all taking place. And unfortunately, at that point, even though Ukraine, along with some of its partners, already sort of started making efforts to prosecute those crimes, I don't think, looking back, that enough was done in order to utilize all the possible justice and accountability mechanisms in order to prevent the 2022 events.
You mentioned deportations, and I will ask you about this separately, because there is a lot of focus on deportation of children from Ukraine to Russia and also to Belarus. Do you see that the scale of deportations was bigger before 2022 or after?
It's a very hard question to answer, because even back then, I don't think, or at least based on what we had been seeing, documentation of those crimes, or even the recognition that those crimes were being committed back then on some kind of scale, was not there. Especially because the territories was not under Ukrainian control already at the time. So it was very difficult to trace and track what had been happening in terms of the numbers. And our prosecutors and investigators have always been saying that investigating the crimes or the violations that have been taking place in the occupied territories has always been a challenge because of the lack of access to those territories. Although I can say that children were displaced from and transferred to Russia. I can't say the numbers from Crimea, both Crimea and Eastern Ukraine, already in 2014, 2015, especially because at the time, Ukrainian government launched an application, interstate application, with the European Court of Human Rights, alleging the illegal transfer of children from the occupied territories to Russia. But then, following that application, I believe that Russian authorities returned those children back to Ukraine. That's why the application didn't go all the way through. But that definitely occurred, and that means that the deportations and the legal transfer, they were already happening back then. Now, obviously, the allegations are that the numbers are bigger, but again, it's very difficult to state with certainty whether those numbers are correct, because if you look at the statistics provided by the Office of the Prosecutor General in Ukraine or the National Police of Ukraine, and the numbers are already different. We, from our perspective, because we represent some of the victims in these cases, the verification procedure is not very robust at the moment. So the tracing and tracking is still remains a challenge, and then the top of that, verification as well. So that's why we know that about 400 children have already been returned to Ukraine. So those cases can be investigated and verified, which is already being done. But for the rest of the allegations, it's difficult to say something concrete.
You have already mentioned there are obstacles towards the documentation of crimes that were committed under occupation. Is it possible, or will it be possible only after the liberation to document those crimes, to verify the numbers? To what extent, which tools can be used for the ongoing documentary work and investigations?
Well, I think that I will start from the end. I think because the answer is pretty easy, the best available tool, a modern tool that we have at our disposal right now is OSINT. Because in order to conduct a full investigation, you do need access to a crime scene. And if you don't have that access, then it's very... Obviously, you can collect, often you can collect witness and victims' testimonies from those who have been, who have not come back, but who have come to stay in the territory under Ukraine's control. You know, it depends on sometimes it's just the testimony of one person, and you cannot build an entire investigation just on the testimony of one person. Obviously, you can corroborate it with OSINT, you can corroborate it with, you know, some of the journalist investigations if they manage to get into the territory. But again, it's all sort of secondary sources, and if investigators and the prosecutors, the professionals, are not on the ground, then it's a challenge. And I think especially the way that Ukrainian legislation is built, the legislative framework, especially the criminal procedure code, you need to have, the investigators need to be the primary source of the collection of evidence, essentially. So I think that pretty much, yes, the answer is it would have to be done after the territories are returned under Ukraine's control.
And in terms of improving the documentation and having in mind this huge engagement of civil society, NGOs, actors into documenting crimes committed against Ukrainians, how do you assess the cooperation between the judiciary and authorities and the civil society sector?
I think there is a lot of willingness from the CSOs to assist the authorities. But again, going back to what I said earlier about the way that Ukrainian legislative framework is constructed, investigators and prosecutors are the only sort of source of those who can collect evidence. So that means that whatever is being brought by the civil society, the evidence that they collect, it cannot be directly used in the investigations. They need to be, you know, these reports, this parts of evidence, they have to be what we call legalized into the investigation. And it can only be done by tracing the same steps that have been undertaken by the NGOs. For instance, if the NGOs interview the witness, the investigators need to go and to re-interview witness. If they brought some piece of, OSINT, they need to retrace all the steps and document them properly, step by step, and only then it would be an admissible evidence in the file. So things like that. And I think in many ways, I mean, it's understandable why it's being done, because obviously, for the professional authorities, for the state authorities, there is a criminal procedure code in place that they need to follow rigidly. Whereas for the CSOs, there is no protocol. So everybody does it whichever way they see fit, essentially. And sometimes the quality of it is not the best. But also, on the other hand, considering the scale of what needs to be done, perhaps we need to find some kind of middle ground, because a lot of time gets wasted on retracing, retracking, reinvestigating, some of the work that has been good, of good quality, and you don't need to waste extra time on doing it all over again.
Speaking about the effectiveness of Ukrainian justice system, how would you assess its achievements until the present day? And if you could shortly talk about the differences between criminal proceedings and investigations concerning the crimes committed after 2014 related to the war in Donbass. Mm-hmm. Few sentences have been delivered before the full-scale invasion.
Three,
exactly, yes. Very low number. And we already know about the ongoing investigations and convictions after 2022. So what are the differences and maybe new strategies of the prosecution?
From a personal perspective, I'd say the differences are not that great, to be honest. Obviously, the decision on 438, the war crimes article in Ukrainian Criminal Code, and interpretation of the 438, what it means, and 437 as well, those decisions were very helpful, but a bit late to the party, because those things that should have been done from the beginning. Because in 2014, obviously, the criminal system was in shock. They were required to investigate, but they didn't know what to investigate. There had been no experience, there had been no legislation, there had been no support from the government to put that legislation in place that would actually facilitate the investigations and prosecutions. But also, I think a lot of it had to do with the fact that we didn't classify the armed conflict as armed conflict back then. It was anti-terrorist operation. And it was kind of like an internal, sort of operation, special operation that didn't sort of require to have, a conflict-related legislation in place. So a lot of the investigations were run under the anti-terrorist legislation, as opposed to, we had about maybe 30,000 investigations open into anti-terrorist crimes. And then some of them were very, very few and far between that would be classified as a war crime. Mostly, also the national police would have a completely different classification, like kidnapping and murder and all of those, basically ordinary criminal offenses, if you like. That confused legal system in a big way. And obviously when things turned around in, 7 years later, in 2022, or even 8, so that made a whole difference, because then it was, the strategy, I mean, we still don't really have a clear strategy in place, but I think it made the life of the investigators and prosecutors in courts a lot easier. At least they knew what kind of legal regime they were operating in. In terms of the quality, I wouldn't say, I mean, it varies because you have the regions who are completely overwhelmed with, especially the near the front regions like Zaporizhia, and you have Kherson, you have Donbas still, Crimea hasn't gone anywhere, I mean, still there. And especially the ones, you know, the areas near the front lines, they're overwhelmed with the incidents that they have to investigate. The security, safety and security is one of the biggest concerns there. They constantly under the risk of being essentially killed when they go to a crime scene and they try to investigate something. That all affects the quality. And also, I think it's very difficult to coordinate all of that work because Ukraine is not a small country. And we have these regional offices everywhere, like in every single, we have 19 oblasts, have several regional offices there, and coordination, especially, you know, in times like this, is insurmountable challenge, I think, you ask me. So we kind of like, we have a different set of difficulties right now as opposed to the pre-full-scale invasion period. But on balance, I don't think that the quality, it affects the, you know, the quality in a sense that it's become better or worse. I don't think it's changing all that much, even with all the international assistance and the trainings and all of that.
Because of the number and the circumstances for ongoing
the scale, the fact that, you know, the armed conflict is still in active phase, the fact that coordination is a challenge, the fact that there is no strategic vision of where we're going with all of this and where we want to end up, because, you know, different institutions and different leaders and, you know, political leaders, they set different goals, and, you know, nobody understands, okay, what's realistic, what's aspirational, where we want to get to with all of this eventually. And unfortunately, in all of this, from my perspective, the victims and their interests get very often disregarded, dismissed in this, you know, chase after the results of statistics and all of this. And it's quite sad.
To deliver the quality trials is a big challenge for Ukrainian justice system and adhere to the fair trial standards. I wanted to ask about the ongoing trials of collaborators. Do you think it is possible to adhere to the fair trial standards in these cases? Are they used for political goals or not? How do you assess those proceedings?
I'm not saying that they don't exist, collaborators. They probably do. But I don't think it should be, unless it's a critical challenge in terms of, for example, we have allegations of people who give away the information about air defense systems and where they located, or location of the air defense, or they give out sell out a very, you know, sort of information that affects the safety and security of civilian population. I think those people, they need to be dealt with. But a very large number, according to our observations and monitoring, of people who get prosecuted for collaboration are people who, for example, they remained in the occupied territories it's one of the cases we have right now of two women, they're two separate cases, but very similar factually, who stayed in the occupied territory because, you know, all the young population, they escaped, but elderly and sick, they remained, and they needed somebody to go to the pharmacy and get them, you know, medicine, or go and support them. So these two women, they were helping in one way or another civilian population, and now they've been prosecuted for collaboration. I think we don't really have any standards. And also we have to understand that the Ukrainian legal system it's a USSR inherited approach. And the way that we used to show results is by way of statistics. These cases are the easiest to pile up that statistical data. You see, these people are within the reach. Normally they're poor, they don't really have any means to get a good lawyer who will get them off. You know, standards are non-existent pretty much in the legislation on how you prosecute these people. So it's an easy statistical gain. And if, you know, the authorities have to report on how many cases they've investigated, it's an easy means to an end. And I think that's where it gets distorted, and we need to seriously revise this approach. And I know that many NGO colleagues, they are fighting with the state system to change it and to start, you know, assessing these cases in a different light and have some kind of differentiating approach. But I don't think we're there yet.
You did mention that previously many of those people who were prosecuted, they were prosecuted based on anti-terrorist act. But you think that this was also the result of the ongoing proceedings of in the International Court of Justice, that Ukraine sued Russia based on the convention prohibiting financement of terrorism, or this was not totally unrelated, it was just unpreparedness of Ukrainian system to name war crimes with war crimes notion?
I think I remember those days when we were having these debates with the authorities as well, why they actually decided to, you know, replace the notion of armed conflict with anti-terrorist, you know, special operation, whatever. And the unofficial explanation that we were getting was, if we call it what it is, the armed conflict, then that means that there are two parties to the conflict and Ukrainians would also be responsible. Mm-hmm. And they wanted to, well, the government, they wanted to avoid any kind of talk or allegations of any sort of responsibility. The ICJ case followed. I know that I remember we were trying to convince, again, the authorities not to launch that application, the ICJ, alleging violations of ICSFT, just because we knew that there would be no case, essentially. It was very risky to go under that. I mean, it's complicated, it had never been litigated, and it was very difficult to find proof of evidence to support the claim. But Ukraine decided that they needed to do something internationally, and that's what was available, because both Ukraine and Russia ratified that convention, and in that case the ICJ was available. Same for the second convention,
on the elimination of racial discrimination.
Yes, racial discrimination.
But exactly. To be fair to to Ukrainian authorities, maybe this part of the case was not proven, and Ukraine didn't win this part. But for example, based on CERT, on the Convention Against Racial Discrimination, some issues they were able to prove, and they win in the ICJ, and I think that this was also a huge achievement.
CERT, yes, I mean, my organizations, we never dealt with sort of partially and indirectly. Sometimes we were engaged with Crimean issues, but on a minimum scale. But back then, when we were discussing this case, with regards to CERT, with Crimean colleagues, it did sound like they were in a better position to bring that claim on the CERT. But the ICSFT was you could tell from the beginning that it was a very, very risky business.
And you could hear that already we talked about the efforts of the Ukrainian judicial system. We mentioned International Court of Justice, but also we could hear about efforts of Ukraine, but also third states which support Ukraine to establish a special tribunal for the crime of aggression. And when you look historically, and you look, for example, at the proceedings in Nuremberg, the problem was that the focus was very much on the crime against peace. This was the former name for the crime of aggression. And we know that those negotiations of the statute of the Special Tribunal for the Crime of Aggression, they are prolonged and prolonged. There are many issues which are not solved, like, for example, immunity of the most important people in the state, Troika, head of the state, head of government, Minister of Foreign Affairs. And in Nuremberg, we could see that prosecution of aggression overshadowed other crimes. Do you think that those efforts which are devoted to the prosecution of aggression are really worth doing, or maybe it would be better to focus on other crimes like war crimes, crimes against humanity, perhaps genocide?
Thank you for this question. It's my favorite. Because for many, many years now, we have been advocating for establishing a special accountability mechanism for Ukraine, even since before the full-scale invasion. And our position has always been that we need an accountability mechanism for all crimes, not just the crime of aggression. Crime of aggression popped up following the full-scale invasion again. But obviously, as you mentioned, you know, the core group who are sort of responsible entity for negotiating the establishment of the tribunal, they are stuck. It's not just the question of immunities of Troika, but also it's the question of the definition right now, where I don't know if you've heard, but there are two approaches currently being discussed. One of them is the Rome Statute definition of the crime of aggression, where it's the responsibility of the top political leadership and military. And then you have a Ukraine's definition of the crime of aggression, which is everybody can be prosecuted for that crime, even the lowest level of, you know, just a regular soldier.
We have the same definition in Poland because it is Nuremberg-based. Yeah.
Yes. So, and I think Ukraine is insisting on its own definition for the tribunal, because obviously the question, if it's a hybrid, which is what they've decided on for now, and I don't think their position is going to change. I mean, unlikely. If it does, then great. But if it doesn't, then, you know, the hybrid will not then overcome the immunity. So it's the next issue, right, that they need to grapple with. That's why, I mean, for now, for me, it's very clear that the obviously some kind of special mechanism will be established. And if it's the tribunal in the current, the way it's currently looking, then it's going to be a fiasco for the entire country of the victims. I don't think we will get to the point where, you know, the existence of this tribunal will make any kind of sense. Obviously, from the academic perspective, I think it might be interesting because many issues pertaining to investigating and prosecuting the crime of aggression will be debated, and probably some solutions will be found. But it's not going to be very linked to the reality of the violations that the people in Ukraine have been suffering all these years. And I don't think it's the purpose of justice. Kind of like, I mean, in some way, yes, but not, you know, in what has been, because the expectations that have been set in Ukraine is that everybody's going to get their justice. And unfortunately, if we end up with the very limited hybrid tribunal just on the crime of aggression, it's not going to be the case. You know, at the end of the day, the politicians will say, oh, well, we tried, you know, say it didn't happen, but we did everything we could, which I don't necessarily agree with, but I will have to swallow it and move on, like it was with Nuremberg, you know. I think Germany learned its lesson, and it was a blessing in disguise for Germany. But for the rest of the other countries, allies, the victors, states or countries, I think it was a big loss, especially for the USSR, because I believe that had the USSR been made responsible for their portion of what they did, perhaps many wars wouldn't have taken place afterwards.
But also, I think that we need to look at those negotiations maybe in a broader sense, in that we also talk about the way we need to compensate victims, and perhaps to bring the problem of the prosecution of aggression helps Ukrainian authorities to say that we need to have better compensation, because we are not just victims of war crimes, crimes against humanity, but we are also victims of aggression. So we need to compensate all damages. I think that maybe this is something of certain value for the political negotiations, which perhaps ordinary people don't see at the moment, yeah, because they see the direct injuries which they suffer. But also, you mentioned about statistics and this attachment in our region to the statistics. And I must say that when you search data, they look quite impressive, because you could learn that the Ukrainian prosecution deals with more than 100,000 of cases which are investigated, which sounds like enormous number, how you manage to prosecute so many people. And we are fully aware that majority of those people are not in Ukraine, yeah, but Ukrainian law has a possibility to have in absentia trial. And from your perspective, this is an effective tool? Because why I'm asking, from the Polish perspective, it's also very important, because even our Minister of Justice announced that we should think about maybe in absentia trials also to help Ukraine to prosecute war criminals. But you can see it from the ground. So what is your perspective?
Yes, it's a very interesting and very relevant question, I'd say. So in the summer, we published this huge report where it's a needs assessment of justice system. It's available on ULAG's website, and we had in September, we had a presentation, and one of the panels that we had was dedicated to the domestic processes. We analyze all the efforts, justice efforts, but that particular panel was dedicated to the domestic processes. And one of the issues that we were discussing, and it's discussed in the report, is the trials in absentia. The majority of prosecutions that have happened so far, they have been in absentia. We have very, very few sentences against people physically present in court, and most of them are against low-level perpetrators. Nobody knows the number of how many people have been prosecuted physically or what happened to them afterwards. Our guess, based on the past and the experiences from the past, that most likely these people have been exchanged. We also, one of the tools that we often employed in order to measure, the public opinion on some of the justice efforts and sort of tools that are being used is the polls. We cooperate with sociological institutions like agencies, and they do questionnaires. We develop the questionnaires together with them, and then they interview people. Sometimes it's in-depth focus groups. Sometimes it's just a question and answer. But it gives us a very sort of clear picture of the public opinion. Some of the issues very valuable, because it always keeps you very grounded. Sort of, when you develop some ideas or you need to run them by, are they actually useful for the people, the ones who you're working for, essentially. And so the question of in absentia came up in many of our polls. And the general opinion is very interesting, because we asked the military what they thought about the trials in absentia. And their opinion, in two questions that came up, and one of the questions was, do you support? You in favor? That was split, almost like 47 to 43 something, right? And then it came up in another question, but it wasn't directly mentioned as, you know, oh, are you in favor, do you support trials in absentia? It was more kind of like, so do you think that meaningful justice can be delivered if a person is not physically prosecuted in the court? And the overwhelming majority said no. Mm-hmm. So I think, and this is the mantra that has been repeatedly, repeatedly said by our authorities, that, you know, when we don't have access to the perpetrators, this is the best next thing. At least we have a sentence or a decision against that person, and then we will catch them, and they will be, you know, serve their sentence or whatever. But the reality of the situation, those who understand how Ukrainian system operates, is pretty isolated at the moment, at least until we, you know, become the EU member at least. It's very unlikely that Ukrainians will ever get their hands on these people. And that means that it's, what kind of justice is that exactly? You know, and we studied several European systems and their approach to in absentia. And we know, for example, like in Germany or in the Netherlands, they do have in absentia, but it's applied in very exceptional, very limited, like economic kind of cases where, you know, somebody owes somebody money for unpaid bill, so the amounts are very small, and so it's not really. But if it's a serious crime, they don't use in absentia, save for MH17 process. But again, it needs to be balanced against, you know, the public opinion, public demand. You know, they accept, like the Dutch victims, they accepted that decision of that court in absentia. Whereas from what we're seeing from our population, I don't think they, in their majority, support trials in absentia when it's related to grave crimes.
This is also the question what we consider as just, fair, yeah, when we talk about the prosecution of war crimes. And I would also ask you difficult question, difficult of course for a Ukrainian woman, because we've heard many reports that there are also some war crimes committed by Ukrainian armed forces, and we are fully aware that they are not investigated, and there is a little chance that they will be investigated in Ukraine. So do you think that there are other tools how we can address the problem of those crimes?
Until recently, well, it's a complicated question in the way that I don't know how Ukraine will, and there are several layers, I think, to the answer, because until the Kursk cooperation, I think that had been the case. What you're saying, it was right. But after Kursk operation, we've heard allegations that there's been a unit set up within the OPG responsible for investigating the actions of Ukrainian armed forces in Russia. Another component that kind of needs to be weighed in as well, you know that Ukraine finally ratified the Rome Statute. I mean, obviously, this one final step needs to be made, two actually, signing of the implementation law and then depositing the instrument of ratification. But at least the parliament of Ukraine voted in favor of ratification.
But the same parliament also declared that they want to submit a declaration based on Article 1 to 4.
Exactly. And I think that the setting up of the unit has to do with that process of the declaration under 124. because
Just to explain maybe for our listeners, declaration based on Article 1 to 4, this gives possibility for the state which ratifies the Rome Statute to exclude for 7 years the prosecution of war crimes. What is here particularly interesting, that Ukraine doesn't want to exclude prosecution of all war crimes, but only crimes which would be committed by Ukrainian nationals.
Exactly. This is very right, yes. So the idea is that Ukrainians are saying, for the sake of avoiding of being accused that you're trying to shield your own nationals, Ukraine, by setting up that unit, might be demonstrating that, oh, look, but we're actually doing our own investigations. And, you know, we're adhering to the principle of complementarity of the ICC. But again, nobody's going to be able to assess the quality of those investigations. Who exactly is going to be prosecuted remains a big question mark. And for me, it looks like some kind of a game that Ukraine is trying to engage in, again, to avoid the responsibility. Of course, it's not going to be on the same scale as, Russia, and nowhere near. Everybody understands that. But if we're talking about impartial, fair justice for all the victims, then we have to face, the consequences in their entirety, not just, we face them here, not face them because otherwise we will have Nuremberg #2 and the consequences of that.
So I understand also, Nadia, that you are concerned that some steps are just taken for the public and not necessarily they will bring a real results which will be satisfying for us from the perspective of justice. And here I have a follow-up question, because also many states which support Ukraine, they wanted to prove that they are doing something for justice. So even they opened investigations, they call them differently. Sometimes that this is subsidiary investigation or that they are on their own. But do you, from Ukrainian perspective, do you see the use of this evidence which is collected by third states in Ukrainian judicial system?
No, it's impossible because, like I said earlier, Ukraine can only use the evidence collected by its own state authorities. So whatever is being investigated by third countries, they cannot use unless they actually request that information specifically within the mutual legal assistance mechanism, and somehow they legalize that information. Otherwise, most of this information it cannot be used.
So do you understand well that those third states which announce that they collected so much evidence, if they really want to prove that they are doing something for the justice, they should start prosecution on their own, because
pretty much, or pass this information on to the ICC, or if at any point in time we have that accountability mechanism in place, a special tribunal or whatever is going to be called, then we should envisage the possibility of using that information in a tribunal as well.
We try in Pilecki Institute always to build bridges between past and the present, and try to have lessons learned from the past. And what we also could see during the World War II, when many nations were fighting for the justice, that sometimes you could observe a kind of competition of victims to stress who suffered most, whose sufferings was greater, and then focus attention. Do you see now the problem with outbreak of also of armed conflicts in the Middle East, that you need to compete for this attention to really focus to achieve this justice also in Ukraine?
I think it depends on the fora, but I think the dynamics within the civil society and the victims, victims communities, is slightly different to the sort of political environment and how everything is being handled in political dimensions. Because when the Israel-Palestine armed conflict broke out after the 7th of October, everyone's expectation was that there would be some kind of competition. And the one forum that I'm often take part in is the ICC. We have annual roundtables there. We have the Assembly of States Parties. At least twice a year we go to The Hague. And it's kind of like collective events where, you know, we have representatives of many countries, the NGO representatives present, including the Israel and Palestine. And actually last year, the Assembly of States Parties was held in New York. It happens once in 4 years. Normally it's, for 3 years, it's held in The Hague, and then once in 4 years, it's held in New York. And we actually did a side event on many conflict situations in the ICC under investigation. So we had Venezuela, Afghanistan, Palestine, Ukraine, all part of the same panel. And what was beautiful about that panel is that we were all supporting each other in all our interventions. It was very inspiring, and it was always, you know, so heartwarming to see people that can actually relate to you, and you almost speaking the same language, even though you come from completely different, and Libya as well. So you can imagine the geography, right? And we saw many parallels and many common issues that transcend, you know, all this geography. It was very eye-opening as well. So I'd say that among the civil society, I don't think there is a lot of competition, more support. But if you have to draw someone's attention, I think it depends on the skills of the people who try to do it. And also the motivation and the sort of the reasons why you're doing it. If you come with a good enough reason, I don't think you have to compete with for anything really. But obviously, if you know, trying to pursue other agendas, then it might be a bit difficult, like to get more money or, you know, to get more political support. But if you're actually advocating for people's values, you know, I think then it becomes a different game.
It's very optimistic what you're saying, because we could hear many claims from the states of Global South that the Ukraine is just a regional problem, but you can show that these are shared problems and that we are fighting for the same values which are important in every region of the world. Nadia, we are very grateful for this talk and for that you were very frank with us and to talk about all those problems. It was a great pleasure. Thank you very much.
Thank you so much for your insightful and very relevant questions.
Thank you very much.